Okay, welcome back to another episode of the Legal Lowdown. I am your host, Matthew R. Carpenter, an attorney, and today we are recapping SEC enforcement trends from the week of June 16th, 2025. During that week, we mainly saw the SEC wrapping up a few cases that have been lingering for what seems like years at this point. Specifically, we saw settlements in cases involving non-disclosures to the SEC, misrepresentations or false statements made to the SEC, offerings fraud, and insider trading. So the SEC doesn't like it when you stop talking to it, when you lie to it, and when you lie to investors. Sounds like my last relationship. Okay, so first we got SEC v. Vanderbilt coming out of the Southern District of New York, which has turned out to be a very popular venue for cases in these recaps. This case, SEC v. Vanderbilt, serves as an example of what happens when people make false statements to the SEC. It involved Roderick Vanderbilt, the chairman of Vinco Ventures, and his romantic partner, Theodore Farnsworth. Thug in love. The complaint alleges that the duo participated in a scheme that resulted in false statements being made to the SEC. Apparently, the participants in the scheme were being paid to lie about the company's performance. And while all this was happening, the share price of the company was actually tanking. It went down from around $6 to just a few pennies. The defendants eventually consented to a bifurcated settlement with the SEC, which is basically when only parts of a case are resolved by settlement, right? A bifurcated settlement allows for certain issues to be resolved quickly while leaving others eligible for alternative forms of resolution. And alternative resolution is exactly what these gentlemen got. In addition to being barred from holding office and director status in publicly traded companies, the DOJ filed a parallel criminal action against them too. So yikes. Okay, moving on to another false statement case or misrepresentation case, SEC v. Lopez. This case comes to us from the Central District of California, and the defendant's name is Sergio Lopez. He served as an officer/director of Canadian public companies and also acted as a U.S. company executive. I want to say hype man. As you will see, the SEC complaint alleges that Lopez and his associates wrote articles and otherwise promoted American companies, like advertised them and spoke highly about their investment return prospects. But the caveat is that Lopez held himself out as someone who was independent, not necessarily influenced or attached to these companies, and that turned out not to be true. The complaint alleges he was paid by the company somewhere along the lines of $200,000 to make these favorable laudatory statements. And in the end, Lopez agreed to settle the case brought by the SEC. As a result, he ended up being subject to a permanent injunction, and he also has to pay $8,000 in disgorgement, as well as $115,000 in penalties. Lopez, like Vanderbilt, in the previous case we talked about, was also barred from serving as an executive or director for U.S. companies, at least in his case, for the next 3 years. So next we're moving from basically misrepresentations, false statements to the SEC to offering fraud cases. And maybe it's just me, but it feels like the SEC is always cracking down on offering frauds, no matter what the administration's stated priorities are. My sources indicate that these cases are brought repeatedly, and they just keep happening. So what makes them so common? Well, I think they often prey on the lure of quick or guaranteed returns, or maybe some groundbreaking tech. Like, people are always falling for that because they so desperately want a way out of the situations that they're in, and unfortunately, they're taken advantage of. And I think the SEC really cares about stopping that. Which really brings us, to a question for you. With these sophisticated scams out there, right? Like, what's your due diligence process look like? It's a crucial thing to think about. Me and my grandma have a code word. But anyway, take the SEC v. Spears case from the Northern District of Texas, for example. This one was filed a couple of years back, just resolved. The defendant is Brady Spears. Oh, Brady. Not like this, Brady. And other defendants included someone named Chattree Pearson and a company called Blue Star Texas. So collectively, the defendants raised about $8 million from 40 investors, supposedly for real estate investments. But the complaint alleged that the defendants lied about using those funds for properties. And crucially, they never mentioned to the investors that Spears had this whole history of serious securities violations and multiple bankruptcies, basically hiding that from them, right? And less than half of the money that was reportedly raised, remember they brought in $8 million from these poor people, less than half that money made it to real estate investment. So in the end, after the SEC got involved and put belt to the defendants settled with the SEC, and they ended up agreeing to pay millions back in disgorgement and penalties. Permanent injunctions were also imposed on the defendants. Specifically, the defendants are no longer allowed to purchase any type of security on behalf of anyone else or even themselves. So the SEC will make you pay fees, penalties. They will also permanently enjoin you from doing certain things like trading securities on other people's behalf, advocating for others in a financial way. You're no longer allowed to be a fiduciary because you can't be trusted, basically. Okay, and so there was one other offerings fraud case. Man, these people just can't get enough, honestly. They love it. Like, chill out, guys. The next case is called SEC versus NDB Inc., which comes to us from the Northern District of California. So we're seeing cases from New York, Cali, Texas, all that. The defendants are a company, NDB Inc., and the company's CEO, Nima Gosharfi. NDB is a private startup firm, exclusive, but the allegations in the case are almost hard to believe, guys. Like, seriously. Apparently, Nima falsely claimed that they were developing a nuclear-based battery, and people were excited about that. They raised, as a matter of fact, over $1.2 million. And it shows how, some of these wild claims actually can have real world sway. But anyway, of course, they didn't develop this battery and then they got caught. And so the SEC and the defendants settled. NDB consented to pay a $200,000 penalty, and Nima got a 2-year officer director bar and a $100,000 penalty as well. It just hammers home, doesn't it? Like, you've got to verify the source of the investment proposal, the promoters, especially if it's a deal that looks too good to be true. Even revolutionary tech claims need scrutiny, people. Okay? And it's going to be ever more important when we get into this AI space. Okay, so let's shift gears to the final type of case that popped up during the week of June 16, 2025. Insider trading. Good old-fashioned insider trading. You never stray too far from these SEC dockets. So this case is called SEC versus Brewer. The defendant is Jack Brewer, as a CEO and registered investment advisor for Brewer Capital Management. The allegation is that he traded using insider information about a company called CopSync, even though he was a consultant for the company and had restrictions against trading with their stocks, right? But, he did just that, and he profited. He made somewhere around $35,000 by selling stocks just before an announcement caused the price to drop. Mr. Consultant had insider knowledge, made a profit, tried to bail. The SEC sued and actually won on a motion for summary judgment here. And so basically the court agreed on a lot of the key claims that the SEC alleged, pretty much bringing them closer to a final ruling, right? But the reality is that this case is still technically being litigated for the final penalties, right? But it just shows that scrutiny on insiders is very constant. So, tying this all together, what does this mean for you, my most dear and valued listener? What we're seeing is regulators relentlessly going after all sorts of financial misconduct, outright fraud, misrepresentation, insider trading, you name it. And it really underscores that knowledge is key, right? Especially when you understand it and can apply it. It helps you navigate these markets. It's a solid reminder that while the markets are exciting, you've got to be vigilant, always. So thinking about these patterns of deception we just discussed, maybe the question for you is, what steps could you take to better verify information or investments? And how does hearing about these legal battles change how you think about trust in the financial world? Just something to think about. Thank you for listening to this episode of The Legal Lowdown.